you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Today's March 17th. We have reviews to do first, so bailiff's going to call your name. You're here for a review and come up to the table to your right and stand there. I'm going to review your file with you. And if you don't get called, then you should have been called, go check in with the clerk. Call the reviews.
James Conley, Kevin Conrad, Ronnie Gillespie, Trevor Hodge, Robert Jenkins, Buford Jones.
All right, James Conley.
Yes, sir.
Got case number 22-2720. Mr. Conley's on teleconference. Looks like you've done your community service, paid your fines. The only thing I don't see I have is the driver intervention program. Have you done that?
Yes, sir. I haven't done that yet.
Okay. What's your plan there?
I'm going to do it whenever I get the money. I just don't have the money for it right now.
Okay. Well, you have to do it or you have to go to jail. I mean, that's what the law is. So you got to get that done. I'll give you a couple months and we'll come back then.
All right.
See if you've got it done by then. I'll set it for May the 19th.
All right. Thank you, Your Honor.
May 19th, 9 o'clock.
All right.
Kevin Conrad.
Yes, sir.
231105.
Your Honor, I don't know if it reflects in the folder, but he did do community service Saturday also.
Okay. Okay, it's a good report from RRS. And you still have funds that you're working on, your community services done.
Yes, sir.
Have you got, I guess, probably this last hours you are going toward your fine?
Yes.
Okay.
Yes, sir.
All right, very good. Are you working now?
Yes, sir.
Well, we have to come back on Mondays or Fridays. What's best for you?
Monday would be the best.
Mondays are better. I'll set it for April 28th will be your next hearing.
All
That's
right.
a Monday, 9 o'clock, April 28th. Ronnie Gillespie, 24601. Ronnie Gillespie
What was it?
hasn't done anything on his case and hasn't appeared, so there'll be a warrant issued for failure to appear. Trevor Hodge, 2378 and 79. Okay, community service is done. Okay, he's been at RRS too. Do you have a report?
I'm now at Bethesda, Your Honor.
He's got a discharge from last treatment. Last I heard.
Okay. Where have you been going?
Bethesda.
Okay.
I've not seen anyone yet.
All right, well, just have a seat when we get a report from Bethesda, so we'll recall you when we get a report from them. Usually they'll have somebody here. Robert Jenkins. 12-690, 12-697, 13-2480. You have a payment on your fines today?
No, I don't. I need to know the exact amount of those too, please, if I
And
could.
you've got some community service to do too. I'm showing 2 days of community service to do. Have you done anything since your last hearing?
No, sir.
Why not?
Well, I can't work or anything. I've been to the doctor, so hopefully I can, give you some money here in a few months. Maybe get on a payment plan or something.
We'll let you do light duty. You can't even come in and do light duty?
Some.
Okay, we'll come in and try something. Dust or something. Run the sweeper. Okay, I'm going to set you for April 21st as your next hearing. 9 o'clock. Buford Jones. $20, $27.67, $20, $17.95. You have done some community service. I'm showing you still have 1 day left.
Yes,
Is that
sir.
right? You got a payment today on your fines?
Yeah, I'm gonna pay 100.
Okay. Are you working?
Yes, sir.
These are Fridays for your reviews.
Monday's fine.
Okay, April 28th. That's a Monday, 9 o'clock.
Thank you, Your
See
Honor.
the clerk. Once you get these done, then you can quit coming.
Yes, sir. Thank you.
You're welcome.
David Mills, Donald Porter, John Riggs, Devon Tippett, Denise Sexton, Savannah Spurlock.
David Mills, 23,758. This is 700. It's a good report. And your fines are paid. So, I'm going to finish it up. Case is completed here. Do what you need to do with your recovery and your relationship with Southern Metro. I'm not going to require you to come back for any review.
Thank you, sir.
Completed.
Good job.
Thank you.
Good job. Donald Porter. Donald Porter is case numbers 08441, 181222, 202120. So RRS. He's not compliant with his counseling. Okay, so I'll issue a warrant for his arrest. He's not compliant with counseling and didn't appear for his hearing today. All right, John Riggs, 23,528, this year. And he has paid off his fines and costs and submitted something from Helping Hands of Greenup County showing 30 hours of volunteer services there in Greenup County.
Your Honor, I have not received that yet. He turned it into the clerk's office and it went straight to the folder.
Okay. All right, and he did pay off his fine, so I'm gonna let Mr. Cooper verify that.
Okay.
It's taken a while, but
Yeah.
it looks like things are completed, so check back with probation just to make sure. I'll give you a date, but if the community service checks out, you'll be considered completed.
Okay.
So, I'll set it for April the 18th.
Okay. Just,
9 o'clock.
all right, thank you, sir.
Good luck to you, sir.
Thank you.
Yvonne Tippett, 22-2344, is not here and still has fines to pay. The bench warrant for failure to appear. Denise Sexton, 24-538. I did get text from Mr. Man at ODP about this. Okay, and she's still at ODP and is compliant, so I'm going to give. They didn't bring her today because the liaison is sick, so I'm going to give them a new date to bring her. We'll make it this next Monday, which is March 24th. March 24th, and I'll notify Ms. Dement, she needs to bring her in. Savannah Spurlock, 24-495.
Your Honor, this is another one. She was here Saturday also. I don't know if it will reflect in the.
Okay, it's that part. She has done quite a bit of community service since her last hearing.
Yes, Your Honor.
Okay. Are you going to work on your fines too, or
I was wondering if I could do that through community service.
you can?
I can. Okay.
Yes. So just keep doing community service. It'll be able to toward your fine once you do what you were ordered to do initially. So
Okay.
okay. So we're going to go. Are you working? Doesn't matter if it's Mondays or Fridays. April 25th was your next hearing. That's a Friday. April 25th, 9 o'clock.
Recall Trevor Hodge, case number CRA 2378, CRA 2379.
Have an arraignment, review hearing, arraignment, this hearing.
Mr. Hodge is at the Fed. We got a report.
May I approach?
Yes. Yeah, and he's at sober living now. So that's good. Can you pay down your fines today?
No, Your Honor, I'm about to start working again.
Okay. So do you know what your work schedule will be?
No, not currently, but I can work around it.
Okay. I'll set you for April 25th, then that's a Friday, last Friday of April. April 25th, 9 o'clock is your next hearing.
Yes,
Thank you, Your Honor.
We're ready for arraignments, Your Honor.
Okay. Next hearings are what's called arraignments. Arraignments are the first hearing on a criminal case, or if you got a warrant issued, it's the hearing after you got a warrant issued. So when your name is called, come up to the table to your right, just like the last folks did, which will probably be by yourself. I'm going to go over the charges with you. You have a right to remain silent. You don't have to say anything. If you choose to make statements, though, what you say is on the record, so it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. If you decide you're going to enter a guilty or a no contest plea, you're waiving those rights I just explained. You should not waive your rights if you don't really know what to do, if you're confused, if you don't understand what's happening, if you want a lawyer, if you want a trial on your case, any of those reasons, not guilty is the safest plea to enter. Call the first case.
State of Ohio versus Don M. Goldcamp, case number TRD 25462, A and B.
Ma'am, are you Dawn
I am.
M.
Yes, sir.
Goldcamp?
Yes.
Ms. Goldcamp, it's alleged that on March the 15th, 2:41 p.m., you were driving a vehicle while your license was suspended and it's charged under the first-degree misdemeanor section of the driving under suspension law. Maximum penalty is 6 months in jail, $1,000 fine. You're also charged with failure to keep tags on the vehicle, expired registration. That's a minor misdemeanor. Maximum penalty is $150 fine for that. No jail time. Do you understand the two charges?
Yeah.
Do you understand your rights?
Yeah.
How do you plead?
Maybe I don't understand.
Okay, and not guilty?
Not guilty, yes, sir.
You want a lawyer appointed to represent you?
Yes.
Do you have a job?
Yes.
What do you do?
I run Napa. I'm the store manager at Napa.
Are you paid by the hour? I have to determine your gross annual income to decide if you're eligible for a
About
court-appointed lawyer.
45,000.
Okay, you have children that you're supporting?
2.
Okay, I'm going to go ahead and appoint a lawyer for you then.
Okay.
Mr. Stratton?
Good morning, Your Honor.
Good morning. She has an M1 DUS. She can sign a $1,000 signature bond. Not guilty plea is entered.
Sign right there.
So looking for pre-trials, probably April 7th or after.
April 7th would be fine, Your Honor.
Okay, April the 7th is going to be pre-trial, and it'll be at 10 a.m. Not guilty plea is entered.
All right, thank you. We'll set this up.
State of Ohio versus Ronald L. Dishman, case number TRC 25465, A and B.
Sir, are you Ronald L. Dishman?
Yes.
Mr. Dishman, the state's alleging on March the 14th at 8:25 p.m. in Union Township, you were driving a vehicle while you were under the influence of alcohol, that you took a breath test and tested 11 on the breath test, and that this would be the first, if you got convicted, it would be your first offense.
Yes.
So on a first offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most you can receive if you're found guilty. There is a minimum. So the least you can receive if you're found guilty is 3 days in a treatment program, $375 fine, 6-month license suspension. The test score of 11 on the breath test is over what's called the per se level under Ohio law.
Yes.
Per se level is 8, so the state can be entitled, they're not automatically entitled to a presumption of impairment, they can be entitled to presumption of impairment for a test score of 11, but they have to show compliance with the rules. There's rules about calibrating machines. They have to show compliance with that to get the presumption of impairment. You understand that?
Yes.
The other charge you face is not using a turn signal, that's a minor misdemeanor, maximum penalty is $150 fine. So you have two charges. Do you understand those two charges?
Yes.
And I explained the rights of defendants earlier. Did you hear that?
Yes.
Any questions about your rights?
No.
What plea do you wish to enter?
Guilty.
Guilty means you're admitting the charges are true. By doing that, you're waiving the rights to have a trial, have a lawyer, to make the state of Ohio prove these charges. Understand that?
Yes.
Okay. I'm going to read, the officer usually writes a statement, which I'll find here, and then read it into the record. If you want to make a statement yourself after you hear what the officer says, you can. You're not required to. Okay, and this is a State Highway Patrol citation. The officer writes, on March 14th, I was stationary patrol. I noticed a white vehicle not use the turn signal. I caught up to the vehicle. The driver failed to activate the turn signal 2 more times. Then I activated my overhead emergency lights near Township Road 1043 and intersection Township Road 1038. Driver was identified as Donald Fishman. Contacted the driver, stated the reason for the stop, asking if he had a driver's license. Noticed his watery and bloodshot eyes. There was a strong odor of alcohol coming from his breath. Asked him how much he had to drink, and he said 2 beers. He was coming from a bar in Huntington. Asked him to get out of his vehicle. And he appeared to have difficulty with balance. I asked him if he would go through standardized field sobriety check to make sure he was okay to drive. I asked him about if he had any head, neck, back, or knee injuries. He says he had bad feet. I asked him to walk 9 steps in a straight line. He said he could try it. I asked him if he was on any medications. He said for arthritis and blood pressure. Had him stand with his feet parallel, hands interlaced under his chin. Checked his pupil size. The first portion of the test administered was lack of smooth pursuit. 2 clues were observed on the eye test for alcohol. Walk and turn test. Asking if he could imagine straight line. Asking if he could stand with his left on the line. Before I could demonstrate the test, Mr. Fishman said he could not perform the test because his feet would not allow him to. 1 leg stand, had him do that. Demonstrated the test. Attempted to try this test, it said my legs will not let me do it. Placed him under arrest for ODI, was searched, placed him evidence bag, placed Mr. Fishman in the rear patrol car, given his Miranda rights. On the way to the highway patrol post, he stated he had 3 beers and a double shot of Jack and Coke. Once I arrived at the post, asked him if he would give a breath sample. He provided one, and results were .11. He was cited for ODI release to his daughter. Okay, Mr. Dishman, anything you wish to say?
No. I do have a job.
Okay. Okay, now one thing that's important on the citation, there's a place where he can indicate, the officer indicate whether you have proof of insurance. Do you have insurance that covers you or your vehicle?
No, I was working on that.
Okay. Well, that's gonna, and you don't think that you had it at the time this happened?
No.
All right, so what's gonna happen there, I mean, I'm gonna give you a suspension in my sentence, which is mandatory for our ODI conviction. I'll give you a suspension for that. You're gonna get another suspension from the Bureau of Motor Vehicles. When they see, when the citation goes in, it shows no proof of insurance, they're gonna give you another suspension for driving without proof of insurance. You're required to have proof of insurance in Ohio when you drive. If you don't, if you get a ticket for it, you don't show proof, then the B&B suspends you. So you're gonna have 2 suspensions to deal with. And the other thing is, I can't give you If you had proof of insurance, I could give you a work permit to drive under limited circumstances, but you'd be able to drive to and from work, but I won't be able to do that without proof of insurance.
Okay, I'll work on that.
Okay. So what's gonna have to happen on that, if you wanna try to get a work permit, is go get the insurance and then come back and ask me for the permit, then I can, see if we can figure out a way to make that happen, but I can't give it to you now.
Yeah.
You understand?
Yes.
Okay. All right. On the OVI, I'm gonna impose a $500 fine. I'll order you to pay the court costs. You'll get a 6-month license suspension, that's the minimum, and it'll be effective the date of the instance. It started March 14th. 20 days in jail, but I'll suspend all the jail days on the condition that you do 5 days of community service and go to the driver intervention program. So there's a 3-day school, that's part of the minimum sentence. You either have to do jail or go to the 3-day school. You'd rather go to the 3-day school, I'm sure.
3 days.
Yeah, so there's one here in Lawrence County.
Yeah, my daughter knows that.
Okay. So, you don't have to go to that one. You can go to any one that's approved by the state of Ohio. But there is one here in Lawrence County, so you got to do that to avoid the jail time.
Can I, don't come back to that, be on like a Monday, Wednesday, and Friday. Because that's, when.
No, it has to be all together, and it's a weekend purpose. You go in on Thursday and come out on Sunday.
Okay.
Now, there may be others in some of the bigger cities that are different days.
Yeah.
But the one here is a weekend program. I never known them to offer it any time other than the weekend. Okay, so you got 30 hours community service, 2 years of probation. We'll make it level 4 probation. So you will have a review hearing. I'll set that for September the 8th, so you got all summer to get this done. And if you do get it all done, you don't have to come back for the review hearing. Review hearing is a check to make sure people do what they're ordered to do. So if you don't get it all done, you gotta show up. If you don't show up, you get a warrant for non-appearance. So I don't want you to go to jail. You can go to jail if you don't do this stuff. You'll wind up going to jail. So just do what you're supposed to, and you can avoid jail time.
Yes, sir.
On the turn signal charge, I'll pay the $20 fine. So you're going to meet with Mr. Majors out in the lobby. He's going to be your probation officer. You got to check in with him, and then you're free to go. Do you have any questions?
No, sir.
Okay. See Mr. Major out in the lobby, and you're reviewing, and he'll get you the paperwork. And there's also, and this is not just for you, but everybody's listening. The court has a website under Lawrence County Municipal Court. If you go to that, there's a record search you can do there. Put your name in, your case comes up. It tells you when you got to come back to court, what you're ordered to do. I mean, people say, I didn't know what I was supposed to do when I was supposed to come back. And we actually have telephones here. Nobody answers phones usually. If you got a cell phone, you don't answer it. But we got landlines, so the old-fashioned way. You can call and they'll tell you when you got to come back to court. So that's another way you can go to jail, is blow off your review hearing. We have people do that. They don't show up for their review hearing. Then they get stopped for speeding. Well, they're not just getting a ticket, they're going to go to the jail because there's a warrant. So just take care of it and you can avoid jail. Any questions?
No, sir.
Okay, you're free to go.
Thank you.
State of Ohio versus Sean Frechette, case number TRC 25-474, A and B.
And sir, you're Sean Frechette.
Yes, Your Honor.
Mr. Frechette, it's alleged March the 15th, 3:56 a.m. in Fayette Township that you were operating a vehicle under the influence of alcohol or drugs or a combination of those things. It says there's some priors here. It says 3 priors, so it doesn't give me the years. I'm going to go ahead and arraign it as if it's a third offense, because that makes a big difference on the possible penalties. But I'm not sure. There's a certain look-back period. I'm not sure if it's going to all come within the look-back period. But I'll give you the worst case scenario. So on a third offense, the maximum penalty is 1 year in jail, $2,750 fine, and a 10-year license suspension. The minimum penalty is 30 days in jail, $850 fine, and a 2-year license suspension. The vehicle could be subject to forfeiture too on a third offense if it's titled to you, and the state's alleging that it was titled to you. So, you're also charged with speeding, driving 64 in a 55 zone. That's a non-jailable offense, minor misdemeanor, maximum penalty is $150 fine. You understand the charges?
Yes.
So, with this type of offense, you should strongly consider a not guilty plea. And there's things that need to be investigated here. So you want to enter a not guilty plea?
Yes.
You wish to be considered for a court-appointed lawyer?
No, Your Honor.
You got to hire your own? How much time do you need to do that?
I'm gonna start right today. I'm gonna,
Okay. Well, I'm not setting pretrials now until the earliest would be April the 7th, which is 3 weeks out. Do you think we can do it then, or I can give you a little bit more time?
Yes, I'm unemployed right now. I'm collecting unemployment, so I'm just, waiting to go out to work, but now this. But yes, any time's good. So this is the main thing right now.
Okay. Let's set it for about a month out then, though, a little less than a month. April 14th?
April 14th.
That'll be your next hearing. And even though you're not working, you don't want to be considered for a court-appointed lawyer? I have to ask you about your income if you want a court-appointed lawyer.
No, I don't think I qualify.
Okay. Your next hearing is going to be April 14th at 10 o'clock. Not guilty plea is entered for you. I'll let you sign a $2,000 signature bond. And indicate you will hire an attorney. So there has been an automatic license suspension in effect since the time of the arrest. You understand that?
Yes. I have one question.
Yes, sir.
When you said it was my third, this is my third?
It says number of priors. This is what the officer put on your citation, 3.
So I know my last one was in 2016, 9 years ago.
There is a look back period, but it expands. They're also alleging that you refuse to take tests, so that expands the look back period if you refuse to take tests. So you definitely need to get a lawyer on that.
And we'll know the answer when we come back.
Okay. Any other questions?
No, Your Honor.
Okay. April 14th, 10 o'clock, is your next hearing.
State of Ohio versus Timothy Luckett, case number TRD 21-847, A and B. Timothy Luckett.
Did this person appear today?
Usually don't get it.
Okay, I'll pass it. He's got a bond. He posted a bond on March the 14th, so we'll pass it. Probably should let Mr. Flowers know he didn't appear. So he just, looks like he just posted a bond over the weekend.
State of Ohio versus
Right. Okay.
State of Ohio versus Carl Steinmetz, Kurt Steinmetz. Case number TRC 03-2906.
This is an old case. All right, you're Mr. Steinmetz?
Yes, I am.
Okay, so you had written to court previously and asking for the warrant to be withdrawn, and there was a response May 30th of 2024. So you came in today. Are you still living in Columbus?
Yes.
Okay.
I went about 18 years without even knowing this was, I thought it was resolved because BMV kept showing satisfied on everything, and then when I went to Fed prison, the warrant come up.
Okay.
And then this made me stay in Fed prison for an extra 4 months. And since then, I've been out of, I've been in treatment, and I'm doing programs, and now I'm volunteering I'm out of that. I'm volunteer with my treatments and programs, and I'm doing real good. I just, they're dealing with my paint issues, but I can't even sign my name. I like to do some paint jobs and make some money to do this, but on my disability, I don't make it nothing.
All right.
I'm scraping by.
And I see some proof, indications to follow what you're saying is correct. It just extended your release date from prison, so I'll consider that sufficient to take care of the issue. So your case is resolved by your prior jail time.
Oh, thank you very much. Thank you.
So the case is marked completed.
Thank you.
You're welcome.
State of Ohio versus Tyler Branham, case number CRA 18-1295, TRD 18-3739, A and B.
And sir, you're Tyler Branham?
Yes, sir.
All right, Mr. Branham. This is your first appearance on this?
Yes.
This is an old case too. 18-1295, failure to comply with the order or signal of a police officer. It's a felony 3. Did you ever receive a copy of the charge?
No.
Got an extra one to serve you. This complaint alleges December 4th, 2018, you operated a motor vehicle so as to willfully elude or flee a police officer after receiving a visible audible signal to bring your vehicle to a stop and cause substantial risk of serious physical harm to other people or their property. That's a felony of the 3rd degree. Maximum penalty is 5 years in jail and a $10,000 fine. Then there's also some misdemeanor traffic citations, 18-3739, A and B. Alleges that you were driving at the time with a suspended license. That's a 1st degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. And that you ran a stop sign. That's a minor misdemeanor, maximum penalty $150 fine. Do you understand these charges?
Yes, sir.
You have the money to hire a lawyer.
Huh?
You have the money with which to hire a lawyer.
I do have a job. I don't know what category it falls under. I make about $500 a week.
Okay, do you have dependents?
Yes.
Tell me about that.
I got a wife and a son.
Okay. So you're making about $25,000 a year gross, is that right? Okay, you're eligible at that level with your family size, you're eligible for court-appointed counsel. So I'll appoint Mr. Smith, Tyler Smith. came in on, you didn't get arrested on this, right?
No.
You came in on your own, found out about it, and came in?
Yeah, finally found out about it, came in.
Okay. And you live in Louisa?
Yes.
Okay, I'll let you sign an OR bond. $3,000 signature bond. When would you like to come back for a preliminary hearing?
Your Honor, I am here next week and the week after, so it doesn't, any date.
Okay, that's 24th is next Monday.
That's fine, Your Honor.
Okay. March 24th, the preliminary hearing and pretrial. 10 o'clock. And this was, I think, a Village of Proctorville original citation.
State of Ohio versus Carla Eastep, case number TRC 15-4712A and B.
Ma'am, you're Carla Eastep?
Carla Eastep Parsons, correct.
Parsons? Parsons?
Yes, sir.
Okay. This was a case where it's alleged you missed a review hearing
Yes, sir.
back in January, I think, January 27th.
Yes.
Okay. You admit or deny you missed your hearing?
I admit I did.
Okay. Do you have an explanation for missing?
Yes, sir. I had surgery and I was hospitalized at the time of my hearing. Once I got out of the hospital, I was going to come in on a Monday or Friday, but I got arrested before I made it in on a Monday or a Friday.
Oh, where did you get arrested?
On 52 in South Point, like right before
Here in
Walmart.
Lawrence County?
Yes, sir.
Then how'd you get out of jail?
You released me?
Okay. On the teleconference? You had a teleconference
Yes.
arraignment?
Yes, sir.
Okay. Okay. Well, you had done everything but paid your fine off, it looks like.
Yes.
So you just have to, can you make any payments, or are you gonna work that off? How you-
Yeah, I plan on doing both, making payments and working community service.
Okay, are you making a payment today?
Yeah, I can make a $20 payment today.
Okay. What I'll do is I'm just gonna give you another review hearing. Make your payment today.
Okay.
Set you back up on review hearings,
Okay, thank you, Your Honor.
and we'll go into April. Are you working?
Yes,
Mondays or Fridays? for you?
Fridays, please.
April 25th. April 25th, 9 a.m.
Okay.
is your next review hearing. See the clerk.
Okay.
Make your payment.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio versus ACA Elliott Jr., case number TRC 02203 A, B, C, and D.
You're ACL?
Junior. My dad is senior, yes. Well, my dad's deceased.
Your Honor.
Yeah.
This old case also, we got all these old cases coming.
Yeah,
So very unusual. This is on, it was called a DUI back then. Looks like there was a warrant issued for failure to appear for a review hearing.
yeah, I don't really, I remember coming to court for that. I had to do some community service, and then I had to pay some fines. They I think it was dropped down to like a reckless driving or something like that. But I came in today, I didn't even know I had a bench warrant over here. I work for CSX, I've been there 28 years. They do a federal background check on me every 3 years for my engineer license. And I actually got the woman I talked to in the clerk's office, how it all got started. My daughter's at West Virginia State University, and she was coming home, and she got pulled over, and the officer come up and said, well, who are you? And she said, well, I'm Gabrielle Elliott. And he said, do you know A.C. Elliott? And she said, well, that's my dad. And he said, well, you need to tell him that he's got a warrant in Ohio. And she called me, and I said, a warrant in Ohio for what? She said, he wouldn't tell me, he just told me you need to call over there. So the next day, I immediately called, and they told me to come here Monday or Friday and see what's going on.
Well, you had, it was called DUI back then, that's how old this is. If you had a DUI, it was dismissed.
Yeah.
But you pled to a driving under suspension.
Yeah, I had a ticket in Barbersville that I thought I'd paid,
And speeding
evidently
offense.
didn't pay it all.
You had 30 hours community service, you paid your fine. You
Yes.
didn't do your community service is what's alleged.
Well, I did, I remember the first day I came over, we went up, there's a road that goes up beside Kmart over here, Charlie Creek maybe. We took a backhoe back on top of the hill and come around, there was 2 dump sites up there. We cleaned up the first day I was here, and then the next couple times I come, I picked up trash one day and cleaned up debris out of parking lots. I mean, I thought, I didn't even know I had a review hearing, being honest with you. Mr. Steelpass was my lawyer from Proctorville, and then I had a speeding ticket in Proctorville on, I think the lady, the clerk, she said in 2012 maybe? It was on the road, the new road out back of Rome. My mom and dad had moved over to Rome from West Virginia. I live in West Virginia. And my mom and dad had moved over there to be closer to St. Mary's, to the hospital. They didn't want to move into Huntington. So, but I mean, I'll do whatever you tell me to do.
Well, I don't have anything in the file showing that you did the community service. Maybe you did or maybe you didn't, but I don't have any proof of that. And it's alleged that you missed, the hearing was December 27th of '02.
Yeah, it was early 2000s. I was going through a divorce.
I mean, a lot of it's not going to show up on a federal background check, because it's only a state charge.
Okay, I don't really
But
know.
even like the villages, they may not run it when
Right.
you get a citation there, they may not check it.
I don't know if it matters. Now, I do a lot of volunteer work with youth sports over in my community. I've been doing it for roughly between Wayne and Gilbert. I lived in Gilbert for a while for my job. About 20 years I've been volunteering for, I do youth sports, basketball and volleyball. That's what my daughter, she plays volleyball at West Virginia State.
Did we even have records back to 2002? I wouldn't think we would.
I don't think so, Your Honor.
Okay. All right, well, we usually don't accept those types of community service activities, but under this circumstance, maybe we will make an exception. So
I appreciate
get us
that.
something showing you've done 30 hours of that.
Okay. Do you need any letters of reference, like all the magistrates, the judges at Wayne, I work with one of them's kid now.
No, I don't need that. I see Judge Young just about every day at the Y, so
Okay.
I'll ask him.
Yeah, ask him if he knows AC, the guy that works with the basketball and volleyball kids. They about all know me out there.
Okay, I'm gonna give you, I'll set it out a month. Are you working now, or?
Oh yeah, I've been at CSX for 28 years.
Okay, so it's gonna be a Monday or Friday.
Monday's better for me.
I'll set it for April 28th, get us something in, proving the 30 hours community service, you don't have to come back.
Okay, so just,
I'll be here at 9 a.m. on April 28th.
oh, okay. Okay, thank you, sir.
Mr. Cooper will
Appreciate it.
Thank you. You're welcome.
Now, at this time, we're ready to start some pre-trials.
Okay, we're starting pre-trials now.
State of Ohio versus Norman Garner, case number PRC 24-1950, A and B.
Now, Coach, Your Honor.
Yes. Mr. Summer has done the dip school.
He has, Your Honor. He
72-hour
completed,
program.
yes, he completed it this past weekend. And this is one, Judge, you may have it in your notes, but we put this on the record back on February 24th, I believe. The state was agreeable, given some unusual circumstances, to reduce this charge of reckless operation, assuming Mr. Thurmer completed his DIP school by today.
Mr. Hill?
And that's correct, Your Honor.
Okay. And there was also speedings, including the alcohol?
Yes, sir.
Okay, do you agree with that, Mr. Thurman?
Yes, sir.
Anything you want to tell me before I send you?
No, sir.
All right, the ODI is amended to 451120. On that, I'll tell you $100 fine and court costs. On the speed offense, a $40 fine. Can you pay that today?
Yes, sir.
Okay, no probation, and you see the clerk pay your fine for cost. Case is completed.
Thank you, Your Honor.
You're welcome.
All right, buddy. It'll take a minute to get the paperwork, but just wait until I have it to pay that for you.
State of Ohio versus Johnny Brumfield, case number TRC 2408, A and B.
My approach on this, I'll say that.
Yes.
Your Honor, this case is one that we also resolved back on January 27th. This is similar to the last one. The breath score on this one, I think, was within the margin of, I think it was a .08 something. And the state agreed if Mr. Brumfield completed DIP school to make the same reduction in this one.
And this one, was there a rap that says failure to control?
Sheriff, you ready? Yes. Yeah, there was, Your Honor.
Single car accident? Nobody else's property damage?
No, sir, not as far as we know, no.
Mr. Hill?
And that was our agreement, Your Honor. The test score, for what it's worth, is .083, and that kind of put us in the mind that maybe if there are other things that might weaken the case, which there were, we agreed to do that, and we did.
All right, Mr. Brumfield, you have a right to make a statement to the court if you wish before sentencing. Do you have anything you want to say?
No, sir.
Need to get 2408. So it'll be at 451120. $100 fine and court costs. $20 fine on the failure to control. You pay that today?
Yeah.
No probation then. See the clerk, pay your fine, court costs, and case is concluded.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Michael Henson, case number TRC 2578.
Mr. Waters,
Your Honor, on this one, we don't yet have the urine results back, but I've talked briefly to Mr. Hill about trying to resolve the case, and I've talked to Mr. Henson about it. He is willing to enter a plea without benefit or detriment of getting the urine results, but we were unsure if you would prefer to wait on them or if you would allow us to proceed today.
Where are we time-wise?
We're getting pretty close. It was in January.
Yeah, April 9th, but that's, of course, I think there was a maybe discovery also filed. If not, we still have some time, but yeah, there was discovery filed.
The agreement. Well, I would prefer to have the screen so I know what we're doing there.
So, I've got a few cases, if April 9th's today, I've got a few cases on April 7th. Would you like to, would it be all right to come back on that day?
And there's agreements that if we don't resolve it in the set up the trial, we're going to be outside the...
It'll be close. I did file a discovery demand in the case, so there's tolling there for a period of time.
There is that. I don't know how many days that is.
Well, if you want April 7th, then you may have to waive the time.
Yeah.
Otherwise, I can set it sooner to give us some time to try if we need to.
Let's see, what other days? Do we have any idea when the lab results are likely to be back? Because there's only 2 weeks, there's only...
Is that one you checked on today, or is that the one I checked on?
Two of them from December.
Let's see, I checked on one today. Yeah, this is it. The only thing I got today was still not available.
Okay. Yeah, Your Honor, actually, Mr. Henson doesn't mind waiving time constraints. We're not too concerned about the content of the lab results.
If you waive until the 7th, we can use that date.
Yeah, we'll do that, Judge.
All right. Finished with Price, cases continue to April 7th for a pre-trial, 10 o'clock.
Thank you,
State
Your
of
Honor.
Ohio versus Logan Brace, case number CRB 2513 A and B, CRA 2517 A, B, C, and D. Your Honor, Mr. Delaware, should be called into the pre-trial session.
It's on the sentencing docket.
It was, Judge. This is when I talked to Mr. Heald about briefly this morning. As you're aware, Mr. Brace had completed an inpatient program with the Bluffs. He was referred there from a local treatment provider, and he's currently in treatment with ProAct, but I've had a little bit of trouble getting ProAct to provide me with the records. Logan's got an appointment with him at 2 o'clock today.
Yes.
So we're going to try to get everyone together and make sure treatment records get released to me. Mr. Heald wanted to see that information before proceeding, and we didn't have an objection.
Mr. Hill.
Well, Your Honor, to please the court, these young people are the victims on those cases they already pled guilty to. And this young lady tells me that she was working over in Huntington, and I guess the same day that we were in court the last time, he came to her work. And there's a protection order now in West Virginia. So one of the things that we were aiming for was for him to be successful in his treatment and everything, and maybe avoid taking those pending felony charges to the grand jury. But this kind of behavior makes us think otherwise. So they're here today because they aren't always available to come to court, but they would like to say their part about this, if they could go ahead and address the court today.
Okay. Mr. Delano? They want to address the court. I mean, are you okay with that? Because they may not be available at a future date.
Yes, that's fine. We don't mind that.
Okay. And before you do, tell me your name and your relationship to Mr. Brace.
My name is Lacey Malone, and I'm just a friend, an ex-friend.
Okay.
My name is Tanner Robbins. I'm a friend for a while now.
Okay.
I've known Logan for a long time.
All right. What do you want me to know about his situation and what happened with you?
Nothing specifically that he didn't already say, just the fact that after he was released last time and after the past court date, he showed up at our work, just made us feel uncomfortable, uneasy. He got arrested later that night, and then to do that we went and got a DVP against him, and that was really it.
So do you both work at the same place?
We do.
Okay. Did he come there and attempt to engage with you, or just came there?
Yes. He attempted to talk to both of us. He asked for him over our counter at work, asked our manager to talk to him. And then after, I was sitting out in my lobby on break, and I was eating my food on FaceTime, and he's just standing, hovering behind me. And I get up, and it scared me, and I screamed, and I asked him to please get away from me, and he just kind of loopies around my store, and I went back in the back, and I just called the cops.
And that's when the protection order was in there?
I went the next day.
It was the day after.
Is there a criminal charge that's pending against him over there?
The Gallia we went and did that the next day, and they had 3 days. That's what the court said, and we went over in Huntington. I think it was Wednesday or something. I couldn't remember, but I know that they said that they didn't get a chance to file his. They didn't give him a chance to give him his papers yet, so we haven't even gone through any proceedings over in Huntington yet. But we need to. That's two different ones. This is the second time.
Where is it that you work, the two of you work?
Cookout in West Virginia.
Okay. On Fifth Avenue?
Well, it happened in West Virginia. They can enforce it over there.
Well, what's the state's position on this?
It's a pretty egregious violation of what we expected in order for him to be able to keep the cases here, the felony cases, which is failure to comply with the order of a police officer and improper handling of a weapon in the vehicle and tampering with evidence.
So these things happened on February 24th? That was the last time we were in court. Did you say it was the same day, or?
No, it wasn't the same day. It was about a week after.
Okay. So about two weeks ago, that would have been a week after, would have been around March 3rd.
Yes, sir.
So been any problems since then?
Yes. It's just, he comes and and he will be in a different vehicle every time. And it's either they're sitting out front of our work or they're driving around, and you can just hear the music, and and it goes through our speakers, because he works drive-through, I work the drive-through, and you can just hear it, and they'll do it consistently and consistently. And I just want him to leave us alone. That's really it.
All we want.
That's all we're here for. Just leave us alone.
That's it.
So, Your Honor, I've heard some of this, and Mr. Braces, of course, we didn't realize this at the time, prior to today's hearing. Mr. Brace insists that none of that happened, and if it did, he expects he'll be criminally charged with something in West Virginia, and then there would be video, obviously, from the cookout of Mr. Brace doing these things. Although he denies having been there. He says he hasn't had any contact with these people. Now, on the other side of things, Mr. Brace and his mother have called me repeatedly about posts that the complaining people are making on the internet, trying to reach out to him through other people, and I've told him to simply block them and not respond to any of the messages. So they have not filed any police reports that way, just because I suggested they just hold off for a minute and let things cool down. So I don't know where the truth is in it, but I expect if what they're saying is true, Mr. Brace has got some problems in West Virginia. Would be my guess.
Sounds like they did file
Yes, sir,
something.
we did. He got arrested at cookout at my work the night that I called for being high.
Okay, and is there a video?
I'm sure there is. I haven't exactly, no one's asked me to go in depth like this, because when I called, they just kind of went and took him off the property. And after that, he got detained, and I called, and then we were supposed to do all of this DVP thing last week, and we never got the chance to, because he was not served his papers.
Okay, is that true? He was there at the cookout when the Huntington police arrived?
Yeah,
That is true.
that is true, but I did not have no contact with them whatsoever, Your
I
Honor.
think this needs to go on to the grand jury.
I think so too.
I didn't.
Now, my only question is, I think that the felony cases happened on a different, let's see.
That was a different day.
Oh,
We
yeah.
got a different case on it.
Yeah.
January 9th.
Well, we can take the felony cases. Right, right. Yeah, and really, I was on the fence about the felony cases to begin with.
Well, let's make it absolutely clear, Mr. Brace. You're not to go around these people. You're not to go around where they work.
Yes, sir.
You're not to buy anything from where they work. You're
Yes,
not
sir.
to be in the parking lot where they work. Is that absolutely clear?
Yes, sir.
Yeah, it's different dates. The misdemeanor is a different date than felony.
Does he have a bond up on the felony charges?
He does.
That's the day my computer wasn't working.
Well, it's got all the case numbers on it, the felonies and the misdemeanors, all listed. So how do you want to proceed, Mr. Hill? Do you want to dolly the felonies to the grand jury and keep the misdemeanor here?
I think that would be appropriate, Your Honor. Yes, we'll do that.
Okay, so you still have a case here. I'll allow the bond to stand, but with making clear there's to be absolutely no contact, Mr. Brace, from you toward these folks. Is that clear now?
Yes, sir.
So your case is going, your felonies are going on, they're not going to be reduced at this point anyway. So it's going on to the grand jury for consideration. We'll still have the misdemeanor here, which occurred on a different day. How do we want to proceed on that?
No, Your Honor, what I'd talk to Mr. Hill about is Mr. Brace has already pled guilty to those offenses. We were going to reset it to April 7th to get you information from PACT, if you're interested in seeing that information. He did complete an inpatient treatment with the gloves.
So, we don't have an objection if the court continued to delay the sentencing of the misdemeanor charges, which with understanding by Mr. Brace that anything else that comes up that's not exactly what we expect of him, then we're going to ask for 6 months in jail. So it needs to be completely obedient to the court's orders to stay away.
Yes, sir.
And that means far away. You're not out on Fifth Avenue parading around the cookout or anywhere where they can see you.
Yes, sir.
If you see them, you go the other way.
Yes, sir.
Okay, we'll be back for a sentencing hearing on April the 7th. That's on case number 2513. The felonies under 2517 are knowledge to the grand jury.
Madam Pro Judge, I've got an entry reflecting,
Well, I'll do it later.
actually, I don't know if I have the right case number here.
Your Honor, we're ready to go to the Lawrence County Jail.
Your Honor, on the, is the court preparing the entries on those, or do I need to?
No, the continuances?
Yes.
Yeah.
You've got it?
They're preparing that.
Okay. Thank you, Matt.
State of Ohio versus Andrew Curry at the Lawrence County Jail. Case number CRA 23464 A, B, and C, CRB 23463, CRB 23291, CRB 2361, CRB 22351. Teresa Freer is on deck.
Set for a pre-trial today in Mr. Stiers' case. Andrew Curry.
Oh, I heard Freer, not Curry. I apologize, Your Honor. Mr. Curry is incarcerated at this time. We have a number of things, I believe, still pending here at this point. The most serious of which is an open dumping, and then it's an unclassified felony. I think other than that, we have a collection of misdemeanors that are still pending. I'm not sure what the court and the state are looking for on this. My guess would be some sort of return to treatment. We've initiated that several times.
He's had periods of time where he's been successful.
Yes.
And he never finishes.
I'm going to caution you that anything you say is on the record and it can be used against you, but you have the right to make a statement if you wish.
Yes, I do. I did complete hometown recovery. Yes, I did complete it. I got a certificate. I completed it on, I did it a month early, actually. I completed it, and I didn't kiss it any time. I'll be drugs in my life no more. They got me right. Hometown recovery did.
How long has he been incarcerated, Your Honor?
17.
The arraignment was on the March 10th.
Okay.
Yeah, I'm clean. I'm clean. I've been clean.
Well, I would at least ask for that we set an OR bond, set another date. I don't know what the situation on that property is in terms of whether it's been cleaned up or not. I don't know when the last time we got a report was.
Can I speak on that issue too?
Again, I caution you that what you say could be used against you, but you do have the right to speak.
Yes, the code enforcement came by my house. He said he's not doing so good of a job, everything. Just, he knows I'm on the up and up, everything. That I need to do a bit more progress. Because I've been working too. Like I've been building houses in Kentucky and Tennessee, and I've been working, staying busy. You know what I mean? I was like, well, he said, I understand. Cause I recycle most of the stuff that comes from my job site, so I make extra money for gasoline and all that stuff. He said, just make sure you pick up the plastic, and I cleaned a lot of it up since he's told me that, you know what I mean, but, it takes progress, you know what I mean, and I ain't got license, my lady's got the license, and she got to drive, I can't drive, you know what I mean, but I've been working on it a lot. Like, I figured, probably about 2 weeks, 3, I probably cleaned it all up, I'm just gonna throw it all away. All my yard sale stuff, all the stuff I need to, just to get y'all, report back to the way happy again, you know what I mean, so.
And if I may, Your Honor, I think he's in jail at this point because he missed a hearing a few weeks ago. I got a text from someone saying that he was out of state on a job. I can't recall if we continued it at that point and he didn't appear, or if the warrant was just issued at that point, he didn't appear before it went out. But he's been in jail for at least 7 days from what you mentioned when the arraignment was. I feel like that's probably sufficient for him failing to appear. And if we're going to make any progress on these cases, we're going to need to get him out.
I do have a report from Hometown Recovery in December where it says they were projecting he was going to graduate in January, but I don't have any kind of final report saying he actually did graduate.
He did graduate with us.
He did?
Yeah, I can get you a report. So.
Okay. Thank you.
So at this time, I'm going to ask that we ask for an OR bond on this matter, allow the time he's been in jail to stand for his failure to appear, and set this back. And in the meantime, we get an update from Mr. Summers.
Yeah. I'm happy that he did complete the program. On January 31st, we got a report that he had completed, but he wasn't here that day, and then he wasn't here later on in February. So I'm also encouraged to hear that he still is focusing on the fact that the property hasn't been cleaned up yet, even though this has been going on since December of 2024. So I think what we need to do at this point is, in order for us to be satisfied that we're making some progress on this case, he's got a resisting arrest, he's got an open dumping, he's got a possession felony, and a tampering with evidence felony. And what we would do, Your Honor, is offer that we would not only the tampering charge, we would reduce the possession felony to an M1. We would reduce the open dumping to a littering charge, and the resisting would stand, and we would ask for a sentence on the entire case of 6 months in jail with credit for the time he served, and suspend the rest of it and give him some more time to clean the property up and have him come back with proof. And in the meantime, we'd get whoever, if it's Mr. Summers or whoever it is that's he's been communicating with, we'd make an effort to find out from him. If it's, I figured that everything would be biodegraded by now, honestly, it's been so long. But if he's willing to do that, we'd like to proceed that way.
Do you understand what's being offered? Basically, that would get rid of these felonies, but it would also make you subject to a jail term that will have been imposed and suspended if you don't get this taken care of.
Yeah, I understand that.
Are you agreeable to that, Mr. Curry?
Yeah.
I think that's a great offer for him. I would strongly encourage him to take that offer. And so if the court were to allow those amendments, we would enter a guilty plea to the charges either as they stand or as amended that are at the misdemeanor level.
Okay, well, let's go through the files that we have, make sure we got them sorted out. In case number 22-351, he's already been sentenced on a theft offense. He has $650 in restitution to Kenneth Tyler Crabtree. 0 has been paid. 0. He also has some fines and court costs on that. That's still pending for the restitution and what he owes in fines and costs. 2361 is a theft offense. And that was a Walmart shoplifting. He had fines, court costs, and community service. He's done 0. He's not done anything on the case.
Well, I hadn't even accounted for those, Your Honor.
Then he's got 23,291. This one, I believe, is still pending, and there's not been a plea. This is obstructing official business on May 14th of 2023. When he ran from Chief Salmon's while he was attempting to serve him with a warrant and investigating the theft offense, what the affidavit says. So that's still pending. There's never been a plea on that. That's obstructing official business. It's an M2. Then there's the file with a bunch of cases. This is the one I think you all were talking about. 23,463 is a misdemeanor. That was the resisting arrest. So it's my understanding what's being recommended is he's going to plead to that.
Yes, I think, and is that an M2 or an M1? So I guess that would be 90 days jail, credit for time served in that case. Fines and community service at your discretion.
It's an M2. The fines and costs are kind of like deciding how many angels can dance on the head of a pin. Because Mr. Curry never pays anyway. So what, I can make it $15 million. He's not going to pay it. He hasn't paid anything yet.
I did work on some of my community service while I was in Bethesda.
Okay, so on the resisting arrest, I'll impose a $750 fine. Court costs. $90 days in jail. How many days you been in jail this time, Andrew?
Since, I think 7 days right now.
Okay, I'll give you credit for 7 days. Suspend 83.
If I may, Your Honor, there was an obstructing that we didn't discuss prior. Mr. Hill's willing to include that in the offer that's been made, so we would enter a guilty plea to that as well.
Okay, I'll go back and pick it up here in a minute.
Right.
Okay, then let's set a review hearing, so we won't give him a whole lot of time. We'll set your first review hearing for April 21st, 9 o'clock.
Your Honor, the court may not want to do this, but I had proposed that we reduce the possession charge to a misdemeanor, having plead to that as well as the open dumping. Make that a littering charge, just put it all under the same. And the more I think about it, I mean, 6 months maybe, and maybe it's not enough. Maybe it needs to be a year suspended.
Okay, the next 23,464. The A case is a tampering with evidence. You wanting to reduce that? It's a felony 3. You wanting to reduce that to misdemeanor?
The tampering, you say?
Or is that one you're dismissing?
I was going to dismiss that if you pled to the others.
Okay, that's dismissed. 464A. Possession of cocaine. felony filed, I'll amend it to an M1 misdemeanor under the same statute. $250 fine, court costs, 180 days in jail. Suspend 173, credit for 7. And we'll run it concurrent with the other case. Review hearing is April 21st, 9 a.m. And we're at 464C. It's open dumping. So we'll change it to an M1.
I think littering may be under a different section entirely. It's 37, 67, 32.
Okay. Change it to 37, 67, 32, the statute number. It's an M3. So the maximum on that is 60 days in jail.
Yes.
So 53 suspended, credit for 7. And I'll impose a $500 fine and suspend it all if you clean up the property. To the satisfaction of the solid waste that's gonna.
I believe it was solid waste, Mr. Summers, that has brought this charge.
And I'm texting him right now to tell him that.
Go out and inspect it.
Yeah, and keep an eye on it.
Yeah. So, yeah, be suspended if he cleans up the property. Same review hearing date, April 21st, 9 o'clock. Let's see what else we got. I think that's it.
I think we need to go back to the
obstruction.
And I don't know if it needs to be said, but I would assume that the old charges that were already post-conviction would be set for review hearing on the same date as these new cases.
Everything will be April 21st. And that old case is 23-291.
No. If it's on the document.
Okay, so that's an M2 also. $100 fine, court costs. So that's 90 days is the maximum. Suspend 83, credit for 7. Review hearing on April 21st, 9 o'clock. Okay, so Mr. Curry, you're gonna get out. You gotta stay clean, you gotta clean up the property, you gotta come to court on April 21st. For a review at 9 a.m.
All right, sir. Thank you.
Thank you, Your Honor.
State of Ohio versus Carissa Freer to Lawrence County Jail, case number CRA 25-152. Charles M. Hutchison is on deck.
Oh, that's Athens. All right, Mrs. Freer, I gave you a bond, but you weren't able to post it. So,
I didn't know I had one, but I thought it was going to happen.
no, I mean, they say they'll come get you tomorrow if you want to wait. If you want to wait and agree to go up there?
I'm not understanding.
Well, you had told me before that you wanted the chance to go turn yourself in, so I set your bond at $3,000 cash or surety. If you posted that here, then you've been released in order to go to Athens County, turn yourself in, but you never posted the bond, so you're still in the jail. So now we're back to the same thing.
I'll just take care of it if they can get it done.
But you don't want to you can't post the bond, right, to guarantee your parents, you want me to order them to come get you, and you're gonna wait and agree?
I don't have anybody to it for me.
Okay. So you want to agree to go to Athens County?
Yes.
Okay, so I'm gonna send a waiver down. I already set your bond at $3,000 on Monday, you couldn't post it, so you're still in jail. I'm actually gonna give them a week, but they've already been in communication with Lawrence County and said they'll come tomorrow and get you if you wait, so. We'll send something down for you to sign saying you agree to go to Athens County. I'm giving them till next Monday morning to pick you up, but I don't think it's gonna take that long. If you're still in the jail next Monday morning, I want to see you just like this. We'll find out what went wrong.
No, I'm sorry, is this case number 25-152?
It is.
I missed the whole thing about Judge Ballard. On my screen, it says the court passes the tip and it appears before Judge Ballard.
Oh, okay. I forgot. Have you appeared in front of Judge Ballard yet?
No.
Well, she still had a holder. I forgot about that. She had a holder from Common Police Court too, so that was another reason. If there's not a holder from Common Police, then we can go ahead and do this. If there is one, that's got to be cleared up. Does she have a case in Common Police?
Yeah, treatment of conviction and I'm applying.
And I didn't hear the last thing you said.
I was applying with, I think so.
Your Honor.
You represent her?
Well, I represented her on a case that ended in intervention in lieu of conviction back in January. I have not seen anything indicating that she's back on the docket, but I haven't looked at this week's docket. Give me 1 second and I'll take a look at that and see if she's on it.
Can we tell she's free to go to Athens County? Is there a holder from Common Police?
Well, I don't know, that, I can't tell that from looking, but I would assume that the jail could tell us if there's a holder.
Yeah.
I don't have anything to charge you.
Okay, I'm going to assume that's true and order that she be picked up by Athens County by next Monday morning. She's still in the jail at 10 a.m. next Monday. I would want to see her on my docket. She shouldn't be there. She should already be in Athens County. I'm gonna order Athens County to come pick you up, ma'am, and they say they'll do it tomorrow.
State of Ohio versus Charles M. Hutchinson at the Lawrence County Jail, case number CRA 25142, TRC 25383, DNC CRB 21584, TRC 192635 A and B. And Deshaun Taylor is on deck.
Mr. Steyer's case. Set for funding.
Your Honor, we have had this a couple of, I think we may have already waived this to the grand jury, but we're hoping to find him a placement for treatment in the meantime. We've been unable to do that due to his pay source. So I, at this time, really don't have any option to get him anywhere, but if he gets the case bound over, hopefully the grand jury could see him in about a week. And we could get him into common pleas court and see if they have any options.
Okay, so this is on case number 25142. So you're going to waive to the grand jury?
Yes, Your Honor.
What's the state's position on bonds?
Well, there's a $10,000 cash surety bond, and
He has an OVI here. Is it going to the grand jury? Or is that-
I believe it's the same incident.
it was an OVI crash that resulted in serious physical harm to these young people that are standing behind me. So we'd ask for that bond to remain.
Okay, so the bond will remain 10,000 cash or surety. So 25,142 is waived to the grand jury.
Yes.
25,383 is null to the grand jury since it's a misdemeanor occurring at the same time. He still has old pending or old misdemeanors that are that he pled to, but he didn't finish what he was ordered.
Yeah, I think he has matters that remain post-conviction. I would ask that for now those be set on a review hearing date a little ways down the road, because this may result, this may change how we want to deal with this. So I don't think there's a point in coming back immediately.
April 28th.
So do you understand that if you're out of jail on April 28th, you need to be here? If you're in jail, you'll be on the video like you are now.
Do I have a bond?
You do. It's $10,000 cash or surety. And that's going to travel with the case to common pleas court.
So the OR bond doesn't remain now as a cash surety?
Right. I don't know if that was ever actually set. That was actually, I think that was set, Your Honor, so we would ask to...
He went to treatment.
Right, but I think it was set that way but never executed. So we would ask that the bond be revised back to the 10,000 cash or surety.
It is 10,000 cash or surety.
Perfect, thank you.
Okay.
Did we not leave the TRC case till we have to?
Yes.
Is that in there? I think it's... Who's our witness?
Your Honor, we're talking about
clear. TRC 25-383.
Knowledge agreement.
Okay. And then CRA 25-142 was waived.
Yes.
21st.
And CRB 21-584.
Case 28 for review.
It's great joy this week.
State of Ohio versus Deshaun Taylor, the Lawrence County Jail, case number CRA 25-157. Carl Tooley is on deck.
Sir, you Deshaun Taylor?
Yes, sir. There's a comment here, right here.
I didn't understand the last thing you said.
Yes, that's after, barely kidding, so in here, on this, here goes.
You can or cannot hear me?
I can hear you now.
Okay. I'm Judge Capper. This is your arraignment. You are being recorded. You're appearing in court on a television monitor. What you say is being recorded. So you have a right to remain silent. You don't have to say anything. You do make statements, though it's on the record, so it can be used against you. You have a right to have an attorney and to have one appointed if you can't afford one. Do you understand that?
Yes. Yes, sir.
Okay, so there's allegedly a warrant for your arrest out of Bel Air, Ohio, Belmont County Court. And you have a right to what's called a Rule 4 hearing in this court to decide if you are the Deshaun Tyrone Taylor that's being sought by that court, and if I should order you to go there on this charge. The charge appears to be on driving without an operator's license and failure to appear for an arraignment. Do you understand that charge?
Yeah.
So how do you want to proceed? Do you want a hearing here in this court on this issue, or do you want to agree to go to Belmont County?
Can I agree to go to this court? I don't know where that place is, to be honest with you.
Do you want a lawyer appointed to represent you?
Yes, please.
Do you have a job?
No.
You have no income?
No.
Okay, I'll appoint Mr. Steyer to represent you. Okay, Mr. Steyer, this appears to be a warrant, it's a Rule 4 hearing, appears to be a warrant out of the county court on a traffic matter.
What county is it you're on?
Belmont County.
Do you know where that is?
No, sir.
Bel Air.
Yeah, that doesn't mean anything to me either, Your Honor.
Okay, you want to talk to him? And
Yeah, if I could take the court's file and give him a call, we might be able to get this recalled.
Yeah, okay.
Thank you.
State of Ohio versus Carl Tooley II in the Lawrence County Jail, case number CRA 25-159, CRB 25-160.
Mr. Steyer, I believe there's some folks here that are with the last defendant.
Tony Walters is on deck.
Sir, you're Carl Tooley? Are you Carl Tooley?
Yes, sir.
All right, Mr. Tooley, I'm Judge Capper. This is your arraignment. You have a right to remain silent. You don't have to say anything. You do make statements. What you're saying is on the record. It can be used against you. You have a right to have an attorney appointed if you can't afford one. to have bond and to make the state prove any charge against you beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, I'm gonna go over the charges with you. They were faxed to the jail about over an hour ago, so you should have them. 25-159 is a possession of heroin charge. It's alleged that at Union Township, March 14th, 2025, you knowingly obtained, possessed, or used heroin, a Schedule I controlled substance. That's a felony in the 5th degree. Maximum penalty is a year in jail, $2,500 fine. 25-160 alleges that you were in possession of a drug abuse instrument, that being a syringe, which had and tinfoil and black tar. It's a 2nd degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand those charges?
Yes, sir.
Then it's also alleged in case numbers 23, 325, 05, 1474, 05, 1584, that you missed hearings November 4th of 24. You had warrants outstanding for missing those hearings, and those were over misdemeanor. One was a domestic violence. And then the older cases were traffic matters. Do you have the money with which to hire a lawyer, Mr. Tooley?
No, sir.
Looks like Mr. Warford was your attorney on the last case where it's still pending, so I'm going to appoint Mr. Warford on this case also. What's the state's position on bond?
Well, Your Honor, the domestic violence charge from 2023 has never been resolved.
Right.
It looks to me like he actually came to court at one point and he was cited in contempt.
He went to hometown recovery with an ankle monitor on.
So I mean, we'd ask for $5,000 cash or surety bond at this time, and then try to figure out where to go from here.
I'll set bond at $5,000, cash or surety.
All fail in our house today.
You will not. Because you have failure to appear.
They were supposed to send a letter in for the domestic situation. There should be a letter on file paying them, and they wasn't going to be able to take off the work. So they submitted a letter to the courts. I believe I asked them to dismiss it, I believe.
Next hearing is going to be March 24th on all matters before the court at 10 o'clock.
Can I get a hold of a bail bond? How does that work? So I just have to have $5,000 cash? I haven't dealt with the bond before, so.
We will have bail bonds and contact you. Mr. Morford's going to be your lawyer. He's here. I'll give him files, and you all can talk. Next hearing is a week from today, March 24th.
Okay, thank you. State of Ohio versus Tony Walters at the Lawrence County Jail. Case number CRA 23466, CRB 23467, A and B. This is Mr. Tyler Smith's case. Plus.
I believe Ms. Walters might have been picked up on a warrant.
Yes.
Is my understanding? Okay.
failure to appear
At the last,
back January 10th.
yeah, that's what I have. This is one where she was working on an open dumping case, and she'd completed all her,
Co-defendant just tried to, they reduced it to a misdemeanor.
right. I believe that was the case with this one too, that it might have been on the sentencing docket. I can't remember if it was on the sentencing docket or not. I know that she was getting treatment and had graduated. We're just waiting on her property to be cleaned up, and she's making progress, but I'm not exactly sure.
Well, I don't think the sentencing was ever done. It looks like it was, there was a motion to reduce it to littering, but I don't think it was, she may have pled, but it never was sentenced. This was pending.
Right, and I think we're just waiting for her to get it cleaned up. And now, as far as the reason why she failed to appear, I want to leave that up to Ms. Walters. I'm not sure why she didn't appear at the last hearing. Ms. Walters, can you hear us? Okay, the reason you got arrested is because you failed to appear at your last hearing. And you've missed a couple of hearings in the past, and we've continued, but there was no contact with the court or made as the reason why you didn't appear at the last hearing, so.
Well, the first, in January, I was studying at Lincoln County, and I called and left a message with your office, but nobody returned my call.
Who'd you leave it? Because I don't recall getting a message.
Where your office was, and I had it on my phone.
Okay.
I think we're going to have to wrap some things up here.
That's fine.
So how does the state want to proceed?
Well, first off, Your Honor, this, of course, is the case that's related to Mr. Curry that was just, and I actually sent a message to the enforcement officer, Seth Summers, and he's no longer the enforcement officer. So they don't have one at this point, but he says the place is still a mess. So we want that cleaned up. Now, my record indicates that she pled guilty. We reduced the open dumping to littering previously, but she still has 2 charges pending, obstructing and aggravated menacing, which I
She
believe
was never actually sentenced on the littering. I think it was just left pending while they were working on cleaning it up.
And I don't know whether she pled to the obstructing and aggravated menacing or not.
So that should be 23-467, A and B. Look at it, see what, 467. No.
So I think that we would like to maybe have the same approach as we did with Mr. Curry, just because they all took place at the same time and kind of in the same situation. They kind of come and go and nothing ever gets done. We would offer, if she pled guilty to the aggravated menacing, we would dismiss the obstructing charge. We'd ask for 6 months in jail, give her credit for time served, suspend the rest of it, and make her equally responsible for cleaning up that property, and have her come back for a review hearing, and we'll find out how the progress is going.
Ms. Walters, do you understand what the state is offering?
Yes, the same thing they gave me.
Yes, you'd get credit for the time you've been into this point. The rest of the sentence would be suspended. You get back out. You have to start working on cleaning up that property, okay?
Okay, it'll be doing it as soon as I get home. I got my permit, everything, and I'm just got, he thought I had a license, but I got my permit finally.
Okay, so you'll have to plead guilty, change your plea to guilty for the aggravated menacing to get that sentence. Do you understand that?
Yeah.
And that's what you want to do? You want to plead guilty?
Yeah.
Okay.
Is there anything you want to tell me, Ms. Walters, before I sentence you?
No.
Okay, on the aggravated menacing, I'll impose a $100 fine and court costs. 180 days in jail. I'm going to suspend 170. She's been in 10 days. So I'll give him credit for 10 days. We'll set it the same day Andrew's review is April 21st. For review.
April what?
21st. April
Okay.
21st. That's a Monday.
Okay.
At 9 a.m., April 21st. You
All
have to
right.
be here for a review.
Okay. Not getting out?
You're getting out unless you got something from another court. Now, I need the sentencer on the B case, I guess, is going to be knowledge. That was the obstruction. And then 23-466, I need to go ahead and sentencer on that. Yeah, the B case is knowledge. On the littering, then we'll do the same. That's the 466. That's what I did for Andrew. $500 fine, I'll suspend it all if you clean up the property.
Okay.
Suspend all the use and put it in the body. Okay. 108, well, that's an M3, so 60 days in jail. Suspend 50, credit for 10. April 21st review. Okay, you get out today.
Thank you.
You're welcome.
Have a good day.
State of Ohio versus Michelle L. Wilson at the Lawrence County Jail, case number CRB 25-158. Deshaun Taylor will be on deck.
All right, ma'am, are you, is Michelle Wilson, is that how you pronounce it?
Yeah.
Ms. Wilson, I'm Judge Capper, this is your arraignment. You're actually appearing in a courtroom today on a television monitor, and what you say is being recorded. So you have a right to remain silent, you don't have to say anything, but if you choose to make statements, they're on the record, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have a bail set for yourself, and to make the state prove for these charges beyond a reasonable doubt. You understand those things? Is that a yes?
Yeah.
Okay, you're charged with trespassing, criminal trespassing. The state's alleging that on March the 15th in Perry Township, without the right to do so, you went on lands or premises of another. Fourth degree misdemeanor, maximum penalty, 30 days in jail, $250 fine. Okay, do you understand this charge? It looks like this was at some King's Daughter Medical Center property is where it's alleged the trespass took place.
No, it was at her ex-husband's residence.
Oh, okay. There's a mention of King's Daughter, so it's, that's where they were wanting to take her, I believe. Okay. Do you have the money to hire a lawyer, ma'am?
You're what? No, I do not.
Okay, I'm going to appoint one for you. Mr. Stratton?
Yes.
Okay, Mr. Sean Stratton's going to be your lawyer, Ms. Wilson. What's the state's position on bond?
Your Honor, this is a situation that perhaps the court ought to take a look at the affidavit.
Okay. Let Mr. Stratton read it also.
Correct.
Okay.
Was approach on?
Yes. Except there's a default probably.
Yeah, so I don't know, but anyway. So, one lives in Rush, Kentucky, but the defendant is a South Carolina resident.
So it's got that address, what's correct? That address, the only that address, the house where she was probably.
So who knows? I mean, I don't know what that is. It's criminal trespass. And she didn't know that she was supposed to do that. That's basically, it's the map out issues.
It's not really a criminal. She just went towards the media.
Yeah.
Didn't have any intent, doesn't sound like. She was on this message.
Why did you just know where she went to go? I can tell her not that she can take her off. It's going to go away.
Is there other family members here?
My husband's here.
Okay.
Oh, that's your husband, okay.
What about her
Husband.
Her
Ex-husband.
I don't know anything. He hasn't talked to me or.
There's children?
There are 4. There's 2 that are underage. They're like 11 and 14.
Where are
I
they
asked her
now?
the other day what the youngest was, how old she was now. She didn't even know.
Where with him? He has custody?
He does. She doesn't even know what grades they're in. Because of her mind. She didn't always be like this.
I think honestly, you don't take him since he lived.
Me.
Okay, I'm going to set bond at $1,500 cash or surety. I'll put it on the docket for Friday. That's the 21st. I'm open to other solutions if one comes up before then.
Yeah, I'm gonna call down there, Your Honor, talk to her.
Guilty plea is entered.
Yes.
State of Ohio versus Deshaun Taylor on a recall at the Lawrence County Jail. That's number CRA 25157.
under Rule 4.
It's a Rule 4.
It's a Rule 4.
It was an arraignment today. Your Honor, can you hear me, sir?
Yeah.
Okay. I spoke to Mr. Taylor's family, his fiance is here. She would like to post a bond for him and allow him to go up to Belmont County himself. So I'm going to ask that a cash or surety bond in the amount of $1,000 be set, and that we set this back. I'm not here next Monday because I have a jury trial, but I'm here next Friday or the Monday after. So a date fairly soon to get this, to have him come back and show that he's taking care of the matter. This is a 2014 traffic ticket, and my understanding is that they've spoken to the county up there, and while they have the warrant, they don't even have the ticket anymore. So I'm pretty sure all he's going to need to do is show up there, present himself, and maybe pay some sort of a warrant fee, and likely the warrant would be withdrawn at that time.
And it can be posted today.
Yeah, I believe it can.
Yes.
Okay, there you are. Okay. Yeah.
I'll set bond at $1,000. When do you want to put it back on the docket?
I was going to say, I wanted to give him, it's pretty good distance, I wanted to give him a little over a week, because I'm not going to be here next Monday anyway. So I was going to say I don't remember the dates, let me look at my calendar here. I'm here the 28th, I'm here the 31st, if one of those days is better, or a day the court deems appropriate, as long as we don't have a trial.
Let's do the 28th. So, you want to talk to the bail bondsman, or are you going to post it? If you post $1,000, as long as he shows up, you get it all back. If you use a bail bondsman, you lose the fee that you give the bail bondsman.
My understanding is they intended to use a bondsman, but I didn't discuss that with you. You do have the right, obviously, if you have $1,000, you can post that with the court, and as long as he shows up there and then shows back up here, you'll get the entire amount back. If you pay a bail bondsman, you'll probably pay about $150 to $200, and that money is gone.
I will pay the bail bond.
Okay. Okay, well, we'll do that. I'll just, he's not going to waive Rule 4 hearing, and we'll just set it for Rule 4 hearing.
Well, I think my thought, since he was going to go himself, was that we would just set it for a hearing when he gets back.
We set it for the 28th. The only possible problem here is we don't know the bail bondsman is going to agree to post it.
And that's a risk we're taking. If Mr. Sowers won't take it, I have a feeling somebody would.
Okay.
If I need to pay the $1,000, I can do that.
Okay.
If you feel like that's more comfortable.
No, the issue is just, a bondsman might say, well, I'm not going to bond him because he's here for not coming to court. So then they say, we're not willing. If they're not willing, you can come here and put the $1,000 up yourself.
Okay, so regardless, I can do either one today.
You can do either one today.
Next hearing is March 28th. 10 o'clock.
Thank you, Your Honor. Yeah. Oh. Guys, hang on 1 second.
Okay, it finishes up at the jail, back here.
State of Ohio versus James P. Gibson, case number CRB 2518, TRC 2533, A and B.
Mr. Mr. Morford's case, pre-trial. James Gibson. Have any idea where Mr. Gibson is?
Judge, I don't.
Okay, he's got 7 days to appear before warrant issues.
Thank you, Your Honor.
You are.
State of Ohio versus Barbara Lawson, case number CRB 22709.
Ms. Lawson's at the counseling center.
Everything good at Counseling Center?
Yeah, I'm still an outpatient.
Here's a copy of your letter. Thank you.
It's a good report.
Thank you.
No, it's a good report, though.
Yes.
Good.
Are
Are you on the local children's services case?
What's going on with the Children's Services case?
Go back to court on the 22nd.
She is back to court the 22nd.
Okay, thank you.
What's recommended how to proceed?
Stay the course, Judge?
She's involved in the children's services case. Apparently, she's got a hearing on the 22nd of March on
Okay.
that.
How about coming back in first of May?
Okay.
That's good here, Your Honor.
May 2nd?
May 2nd.
That's good here.
May 2nd will be the next hearing. 10 o'clock.
Thank
Good
you.
luck to the 22nd. Thank you, Your Honor.
Well,
State of Ohio versus Jordan D. Wolf, case number CRB 25123. Mr. Wolf.
Judge, we've asked for continuance of that case. I have somewhere here entry for your approval. The state had no objection to it.
you have a preference as to the date?
No, I don't, Judge. We could do it sometime in April.
April 11th?
That's good here, Your Honor. I have an entry if you would like.
Okay, finished request, case is continued to April 11th.
I think they agreed to continue to March 21st, it looks like. I can put April date in here.
Let's see what that looks like. That's just this Friday.
Yes.
Is that when you want it, or?
Yes, Judge.
That's,
Shoot, had something to do with work.
Okay. All right, I'll change it. It's going to be a very busy day. March 21st.
Yeah, approach.
Yes. 10 o'clock.
Thank you.
Good much.
State of Ohio versus Wilkie E. Dias, case number CRA 2568, CRA 2569, CRB 2579.
I can.
Tyler Smith's cases, except for retrial.
I think, Your Honor, we're back to see if he was picked up, because one of them was an extradition, I think the rest were.
Yes.
No,
He was picked up.
he was.
We had some other misdemeanor old cases. What are we doing with those?
Well, I know that
25, so he's already been sentenced, it looks like.
I know that he had a robbery charge as well, and I believe that was nullied at the last hearing, so.
He has a review hearing August the 11th on a misdemeanor of this year, August 11th, 9 o'clock for a review hearing. The others, 25, 68, 69, and then there was a Walmart theft in here. Are we nulling those, or what?
Well, let's see.
He went to Kentucky, it looks like.
He pled to theft and criminal trespass on February 18th. At least that's my records. And then we nullied the robbery.
He's never sent, I don't see a sentencing.
30 days.
75.
He had, according to my notes, 30 days in jail, credit for time served 9, suspend 10, serve 11 more.
Okay, let me see.
He served a total
It is
of
on the
11.
computer, but I'm not seeing it. Okay, yeah, it was, it was done, it's in the file.
Yeah, I believe that's why we set this hearing out so far to get, so he could serve his sentence before he become eligible to be picked up.
It was done. He has been picked up by Kentucky. Those reviews were all the same date, August the 11th.
Thank you, Your Honor.
State of Ohio versus James L. Fannin, case number TRC 242610, A and B. This is Mr. Stratton's case.
Your Honor, we don't have any, the state has not provided any results in this case. I don't think they're available just yet, so we just asked to reset it. It's been a minute, so.
December 27th.
Yes. They checked this morning. I had Missy check this morning, and they are not available.
I'm going to be here Friday.
Yeah.
When's the time range?
Well, this occurred on 12/27, so 3/25, so a week and a day from now. So I was going to suggest we come back on Friday, and if Mr. Fannin wasn't able to make it, or had other things he needed to do, we wouldn't oppose him not being here on Friday if Mr. Stratton's going to be here on Friday.
I'll be here on Friday. Oh, you don't have to be here. Yeah. Or, he hasn't said that
Is
yet.
there enough time for it to be set for trial then if it's?
Probably not.
I mean, if you get the results on the 21st, I mean, it's going to have to be tried.
So we tried that Monday.
Set it for trial Monday, and if it either goes to trial or It's dismissed.
That's the only thing we can do, so let's do that.
That's fine.
Okay, so I'll set this for trial March 24th at noon.
Yeah. All right, March 24th at noon.
Kind of screwed
State of Ohio versus Jonathan Johnson, case number CR 2578. Jonathan Johnson.
Your Honor, Mr. Johnson contacted me this morning, stated that he had missed the bus down here from Ironton. I'm not sure if there's a shuttle service of some kind that comes down here from Ironton, but he was unable to get here. He is homeless at this time and staying in Ironton, I think possibly at the Mission. He asked that he could continue, which I'm going to do. In addition, I just got a video handed to me this morning in this case, so I'm going to need to review that video and see if it has any impact on our defense anyway. So I'm going to ask to continue this to an upcoming court date that's not too heavy for the court, and I'll attempt to contact Mr. Johnson and let him know the new date.
What's the state's position?
You wanted to move it a week, is that what you said?
Well, it can't be exactly a week because I have a jury trial on Monday, so I'm just going to say on a date the court deems appropriate.
We're okay with
Other
that,
than
as long
Monday.
as there's a time waiver.
Yes, I'm making the motion, so of course there's a time waiver, but I'll also sign one. Also, another matter that is sort of complicating things is that Mr. Johnson's phone was taken into evidence. I don't know if anything's been done with it, or anything planned to be done with it. We've raised the issue before. We'd like to ask that be returned to him. I don't know who has it, though.
Well, we can address it when he comes before the court.
Well,
How are you going to notify him?
I'm going to call back the number that he called me from this morning and hope that whoever's phone that is around him.
April 7th.
We make certain that's a good day. That is, I'm here that day, Your Honor.
April 7th for pretrial, 10 o'clock. Okay, 10 minutes request.
Your Honor, we have an additional case at the Lawrence County Jail. State of Ohio versus Kenya, Wakataga. Case number TRC 25-473, A, B, and C. Yes.
How do you pronounce your last name, sir?
Lawataga.
All right, Mr. Lafataga, Judge Caffer, this is your arraignment. You are appearing in the court in Chesapeake by video conference, and it's all being recorded. You don't have to say anything, but if you do make statements, they can be used against you. You have a right to have an attorney, to have one appointed, if you can't afford one, to have bail, make the state of Ohio prove any charge against you beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, case number is 473. The A case is operating a vehicle intoxicated. State's alleging, that on March 16th at 3:14 a.m. in Perry Township, you were operating a vehicle while you were under the influence of alcohol, took a breath test and tested 14 on the breath test, and that this would be your first time, if you got convicted, it would be a first offense. Maximum penalty, 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days of treatment, $375 fine, and a 6-month license suspension. The test score of 14 is over what's called the per se level under Ohio law. What that means is if you test above 8 on a breath test, and the state can show that they comply with the rules for giving the test, they can get a presumption that you're impaired because the test score is above 8. They have to show the compliance with the rules for giving the test, though, to get that presumption. You understand all that? You got 2 other charges: speeding, driving 68 in a 55 zone. Maximum penalty for that is $150 fine, and driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. So, do you understand the charges?
Yes, sir.
Do you understand your rights you have?
Yes, sir.
How do you plead to these charges?
Guilty.
You enter a guilty plea, you're telling me that the charges are true, you admit they're true, and you give up any right to have a trial and have a lawyer represent you. Do you understand that?
Yes, sir.
Okay. I'll accept your guilty plea. I'm going to read what the officer wrote a report to the court. I'll read that into the record, and you can make a statement in response if you want to. You don't have to, but you need to understand what the officers wrote to the court. It was Trooper Jewell from the Ohio State Highway Patrol. It says, March 16th at 3:14 a.m. I was patrolling west on US 52 near milepost 14 in Perry Township, Orange County. I observed a station wagon traveling west ahead of my patrol car at 68 miles an hour in a 55 zone. It displayed difficulties maintaining lane positioning. My attention was drawn to the vehicle when I checked its speed above the speed limit. I caught up with the vehicle, and speed varied between 58 and 68 miles an hour. I observed it drive a tire width outside the lane in both directions, crossing the fog line and center line. I made a stop and approached the driver's side of the vehicle, contacted the driver, who was Kenya Lafataga. Mr. Lafataga was the only individual in the vehicle. I detected a strong odor of alcohol coming from the vehicle, asking for his license, where he was coming from. He advised he was coming from St. Albans, West Virginia, headed to Portsmouth, Ohio. I asked him for his registration insurance. While he was looking for these documents, I asked him the reason for his trip. He attempted to locate his documents and displayed difficulty with divided attention. He had difficulty locating the registration. I asked him why he was in St. Albans. He informed me he was coming from a bar crawl with a friend. Asked him what was causing his behavior with the driving, and he did not answer. Asked him how much he had to drink. He said he had 1 beer at approximately 6 to 7 o'clock. Asked him to step out of the vehicle to find the patrol car. I gave him a standard field sobriety test. Asked him if he had any reasons for not being able to do the test. He said, no, sir. I gave him a horizontal gaze and nystagmus test. There were 5 clues observed for alcohol, lack of smooth pursuit in both eyes, distinct nystagmus, maximum deviation. I then administered walk and turn test. There was 4 clues. Couldn't keep his balance while listening to instructions. He stepped off the line. 1 leg stand. There was 2 clues. The rest for OVI. Placed in patrol car. Given at the patrol post the form for conducting a breath test, which he agreed to do. Tested 14. Was cited for speed, lane violation, and OVI. Okay. Sir, do you have any statement you wish to make?
Yes, sir.
Okay, on the OBI, I'm imposing a $600 fine. Where you to pay the court costs. 6-month license suspension starting March 16th, the day of this incident. 20 days in jail, suspend 20 days. Order you to do 5 days of community service. Court has a community service program here, or you can do it. You live in Alabama? Is that where you're living?
Yes, sir. I live in Alabama.
Okay, you can do it in your home area. You just have to submit, accept something from a court or a legitimate charitable organization on letterhead that you've done the hours, 30 hours. You have to go to a driver intervention program approved by the state of Ohio. That's a 3-day program, inpatient. I don't know of any that are outside the state of Ohio, so you'll probably have to come back here. But you don't have to come back to Lawrence County. You can go to Cleveland, Cincinnati, Toledo, any place you want to go in the state of Ohio, as long as it's approved. Yes.
Well, Your Honor, I don't know, he's got a day in jail already. I was going to suggest if he just stuck it out 2 more days, he wouldn't have to do that. I don't know if that would serve him better or not.
He's shaking his head.
I don't blame you, but.
I love the community service. I love the community service.
Well, this is different. You got to do the community service regardless, but the Ohio legislature says, I either got to give you jail time or I got to make you go to a 3-day treatment program. So you got a day in now, at least. If you stuck it out 2 more days, then you wouldn't have to go to the 3-day program. So it's up to you. I mean, I wouldn't stay in jail any longer than I had to, but that's up to you.
I'll do it 3 days.
Okay. All right, you'll have to submit proof of that you've done the program. I'll set a review hearing for you for September the 8th. So if you get everything done by September the 8th of this year, you don't have to come back. If you haven't got it done, you got to show up for a hearing at 9 a.m. on September the 8th. You don't show up, and that's when a warrant gets issued for not appearing. Okay, on the speed offense, I'll impose a $50 fine. On the lane violation, a $20 fine. Do you have any questions, sir?
No, sir.
Okay, so you'll get out in a little while after the paperwork is processed. You'll be released from jail.
No, sir.
Okay. We have there's a website for the court, Lawrence County Municipal Court. So if you don't know what you need to do, you can call us here, talk to the clerks, or you can go on and do a record search on the website, and your case will come up, and I'll show you what needs to be done and when your next hearing is up.
Yes, sir.
Okay?
Thank you.
You're welcome. And that finishes at the jail.
State of Ohio versus Justin N. Lagari, case number 0824817.
Mr. Shire's case, set for pre-trial.
Your Honor, this matter is one, the state has made an offer of 3 days in jail on this. Mr. Lagari is adamant of his innocence. We're probably going to need to set a trial date on this.
Okay.
We'd like to go out a couple weeks if we could.
This is probably one that we want a visiting judge.
That's actually a possibility, I think, because of the...
Nicholas Mayo is related, not that I don't really know him, I wouldn't know if he walked in here, but he is related to the clerk here, so I think it would be better, the appearance would be better if we had the Supreme Court assign a visiting.
We might be better off going ahead and setting a pretrial then at this point so that we can find out who's been assigned and when they're available.
If I had to guess, I think we know. So when do you want to do that?
I don't know how long it usually takes to get somebody assigned.
It's not that long, usually, a week or two.
We've come back on The 4th?
That's a pretty busy day.
Okay. All right, does Friday or Monday matter to you?
Mondays are better.
Mondays are better, so,
7th is okay.
7th, I'm here the 7th. Just write that down now.
It's done by computer now, so we just follow computer requests and now. Well, here's an alternative. I mean, I don't know, do you still, well, we still work together. I'll say, Judge Permeans, but he's still part of the same staff, so probably should be better that.
That's probably safer, Your Honor.
Yeah, we'll ask the Supreme Court to sign something.
Thank you.
We're also going to ask for a protection order. We've never done that.
Any objection to that?
I think has there not been one in effect all this time?
No.
Well, I wrote one on the outside of the file, but maybe it didn't get filled out.
You decide you're in here and here, and you do not leave until
I don't see one in the file.
Thank you. Don't leave till this lady gives you a copy of it, okay? But you can wait in the lobby if you want to.
State of Ohio versus Dusty Lawson, case number CRB 21-244.
Your Honor, this is a 2021 case that Ms. Lawson had failed to appear back, I believe, in 2021, and recently found out about realized the warrant was out here, figured out, made the decision to come in here. She showed up here about a week or two ago under her own steam, so you allowed her out on an OR bond. This is we have two matters here. We have a possession of drug abuse instruments and endangering children, which is filed as a result of the alleged presence of the drug abuse instruments around a child. There was a co-defendant who I believe is also obviously is also an older case, but I don't believe he appeared either. He is not here at this time. Do you have any contact with him at this point? Ms. Lawson no longer has contact with that individual. It was her understanding at the time that he was going to ultimately claim possession of the alleged drug abuse instruments and attempt to clear her of any wrongdoing. That obviously hasn't happened. He disappeared. We now have this case. Ms. Lawson acknowledges she did have a drug problem in the past. She is clean now for how long?
Been a while, 4 years since then.
Basically, yeah, this incident led her to getting clean. She is prescribed methadone, but otherwise is free of drugs.
Is there any kind of children's services case?
Was there a children's services case on this?
They sent it over to Boyd County.
Did anything happen with it?
Yeah, they took her because of this going on over here.
And it was your child?
Yes.
She lost her child as a result of this in Boyd County, but this was, I guess, they lived in Boyd County, Kentucky. She still lives in Boyd County, Kentucky, and so they took jurisdiction over the children's services case. I don't have any paperwork to that effect.
Yes. They said my biggest problem was Ohio, is what they said. And she's with her grandmother. I mean, I still live with her, take care of her, but I just don't have custody of her.
What's the state's position?
Well, our notes indicate that there was that Kentucky case going on, and they were aware that this was happening, but this situation was not the reason for that case. And
is that correct? Was there anything else?
We wanted her to finish her Kentucky case plan, and the way we were going to deal with this was probably going to be a dismissal if she was successful in completing the case plan. So obviously she didn't. But it's been 4 years ago now, almost. And the basis of the
She kind of
trial,
slid through the cracks, because she had a bond up, and I don't think anybody ever released the hounds on the bond.
she didn't show up on December 17th, 2021.
And so, and we recognize that there was a long absence, Your Honor. Was the parental rights terminated or just custody?
I think just custody.
Oh, she's indicating custody was taken from her, but not parental rights terminated.
The allegation was that there were syringes, hypodermic needles, open, exposed, and children in the car. So, at this point, I don't know that there's any point in going forward. The children are in somebody else's custody at this point.
You want to nominate?
Yeah, I think so.
All right, case will be nominated.
Thank you. That means dismissed.
Oh, okay. Thank you.
State of Ohio versus Michael S. Clay, case number CRB 2010-23, CRB 18796, CRB 18251.
You may. It's going to be actually up there. We were here Friday, Your Honor, and through the heroic efforts of RRS, he managed to get released on a Friday, which is quite impressive, after court. So he's been, started at RRS, he's been there for a couple of days. I don't expect we're going to know much yet. But we had set the case back here today to make sure he got out. We already have another hearing date set, I believe, the 7th, or, let me check.
Yes, April 7th.
April 7th. I would assume we would keep that date on unless the court wants to move it.
That's fine. We'll keep the date April 7th. He's got to start. We'll see how things go. We'll come back on the 7th. Hopefully we'll get a good report then.
Thank you. Good to see you out. Appreciate you getting out of there.
State of Ohio versus Kelly Key, case number CRA 24499. Your Honor, I believe she's on Zoom.
Mr. Dwyer's case.
Looks like according to according to her last visit, her treatment provider is indicating they expect her to complete treatment with them March 20th. I'm sorry. Yeah, the end of March, it looks like.
Let's say one handle it. It's been a year, coming up on a year.
Yes.
Well, she did provide a lot more detailed summary of her treatment, and her next appointment is scheduled for the 20th. Does this say on here somewhere that this was?
It does say that she is scheduled to complete her treatment at that time. Let me find it.
Last page here. Client's recommended to continue its current level of care and is expected to complete treatment at the end of March.
When's the next time you're going to be here?
April 7th.
So we'd like to continue to then and make sure she gets across the finish line. Sounds like she's done pretty well.
That's fine.
That will look to finalize this on April the 7th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
May I approach?
Yes.
Kelly, did you hear that?
Yes.
Okay, you can disconnect, I'll call you later.
Tell her to get a report the next
We
time.
need a report that you completed treatment when we come back, and that'll be the last one.
Oh,
Okay, thank you.
All right.
Bye.
Thank you, Your Honor.
I did.
So, I want to see how he's doing.
Let's talk about it after.
Yeah, that's what I'm thinking. Can we?
No, but I mean, before it goes to the
Okay.
grand jury. Did you read, hey, Chris? Did you get that thing I sent you from?
Yeah, but I didn't read it yet.
It's pretty, you'll want to go read it.
Like, no.
Okay, you're down there. Go back.
See ya.
I got Well, it's an app. And you can ask questions and it gives you an analysis.
State of Ohio versus Nicholas Atkins, case number CRA 24294, CRB 24295.
I can also scan in a document. I just might come by this morning.
Yeah, you can.
Your Honor, I'm covering from Roger Smith today. He represents Mr. Atkins. I believe Roger's in a jury trial in front of Judge Finley right now.
When do you want to continue? Did he give you some dates?
He gave me some dates, Your Honor. He said, I don't know how far out you want to go, but I'd assume 30 to 45 days would be appropriate. But he gave me April 11th, April 18th, April 25th, May 2nd, May 9th is your...
About the 18th, April 18th.
Okay.
State of Ohio versus Michelle Atha, case number CRA 2595, CRB 2596.
Mr. Smith's case also, she's at Bethesda. It's a good report. He's getting started really. Yes. It's a good start. Come back in about a month.
That's fine.
Same date.
Same date, the 18th.
April 18th will be the next hearing.
Your Honor, she had cases in Ironton Municipal also that we resolved last Thursday. And one of the outcomes of that was that we wanted her to be in treatment like she is here, and we're glad she's doing well. She pled guilty to misdemeanor possession. We reduced it from a felony to a misdemeanor, and she got 6 months in jail suspended and in order to go to treatment and probation. And we'd like to do the same and just make it concurrent with the Ironton sentence. Or we could even ask her to be consecutive, so it could potentially be a year, but what we want her to do is be successful.
Your Honor, I don't leave that to our counsel to address that, so that could be something they could do on the 18th.
All right, we'll take it up on the next hearing, April 18th.
All right, thank you, Your Honor.
State of Ohio versus Thomas Cove, case number CRA 2576, CRB 23128, A and B, CRB 23742. Thomas Cove.
Star's case.
Yes,
It's a good report.
Good job.
Continue to monitor.
Yes, Your Honor, this is we're pretty early along on the 25 CRA 2576, so I think probably that would be appropriate at this point.
Okay. 14th or 18th of April.
You just sign this right here.
Let me take a look. I've got a couple days in April that are a problem, but I don't know. Actually, I'm unavailable the 18th, but I am available the 14th.
April 14th.
Thank you, Your Honor.
Thank you. Keep up the good work, man.
State of Ohio versus Larry Duffield, case number CRA 2593, CRB 2594.
Star's case.
You signed it right there. Please don't take it.
How's it going?
Doing good. Doing real good.
You gained some weight since you came in here.
Yeah, I've gained about 40 pounds.
Your face is filled out quite a bit more than it was the first time I saw you. It's good, okay. Same date,
Same date would work, Your Honor.
April 14th.
Thank you, Your Honor.
Good start, sir.
Good start. Keep it up.
Thank you.
April 14th. Okay,
Thanks.
thanks.
State of Ohio versus Gretchen Smith, case number TRC 221661, A and B.
Your Honor, my name is on this one, but it's post-conviction and I haven't been reappointed.
This is on the sentencing, there's a bond up now. Got a report.
Yes.
Councilman
April
King.
14th. Okay, here's the agreement.
Okay. Well, let's do a screen, because it says you missed a screen.
Okay.
One that they did, and I have the results of that.
Okay.
Thank you.
State of Ohio recalls Timothy Luckett, case number TRD 21847A and B. Timothy Luckett.
I don't know why they would have called him. I mean, I do why they would have called him, but he had failed to appear back in September, and I said, "Then bond for license suspension, potential work to stay in effect." And it says arraignment today.
Your Honor, I believe he's bonded out.
Oh, that's right. He bonded with salaries. And then still didn't show up. Okay.
And Mr. Savage was another.
Oh, okay, now I remember. He had and I'm surprised that he took it.
It wasn't him, Your Honor.
Oh,
It was his son.
And he's out of town, right? At the moment.
okay. Because he had just forfeited before, he didn't want to get to Detroit and try to wrestle somebody. So I set a bond at $3,000, didn't think he would get anybody to take it. Okay, we're giving him the good news. Does he already know?
Yes, Your Honor.
So it may be coming out of somebody's allowance money. So we need to set a bond forfeiture, April 21st.
I'm going to like his number again, I'm sorry.
21,847. So if we get, we'll make $5,000 off of this on bond forfeitures. If Gary pays this one. Okay, so all we got left on the screen is, okay, I'm gonna take a recess while we're waiting on the results. Court's in recess.